Real people, real cases. This is Verdict Watch.
E30758 on behalf of the Stackpool.
Okay, and good afternoon, your name for the record, please.
Jessica Stackpool.
And you just speak up, please.
Jessica Stackpool.
Okay, so today is the date scheduled for a probation violation as well as a jail review. Ms. Stackpool was sentenced on November 27th to a 1 count of domestic violence. The court also ordered 45 days jail and with 11 days credit upon confirmation, and she was to report December 2nd of 24. The court also, on November 7th, Ms. Stackpool pled guilty to a bond violation, and the court suspended that 14 days jail that it ordered and reviewed the sentencing date. And so that's what the jail review portion is from the bond violation here.
So I never saw that, Sharon, so I wasn't sure what it says jail review on that.
Yes.
On my original docket, I didn't see it.
And so that is why, the jail review, if there's a probation violation, then that just comes back up on top as well, the jail review. So the court will note that since that date, it's alleged that Ms. Stackpool tested positive for cocaine and had a diluted sample on February 24th. And counsel?
That's correct. Your Honor, I have discussed with Ms. Stackpool her constitutional rights. I've reviewed the probation violation, and at this point in time, she understands she has a right to a hearing. Rather than have a hearing, Your Honor, she wishes to plead guilty to the charge. We will address the recommendation.
Okay, now please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
And you heard the allegations, correct?
Yes, it's correct.
And as to the allegation, ma'am, how do you plead?
I plead guilty. I take responsibility.
All right. And you understand you do have the right to have a contested hearing with your probation violation, correct?
Yes, Your Honor, I do.
And you understand by entering into a plea, you will not have that hearing?
Yes, I do.
You understand the possible penalty as a result of your plea as well, correct?
Yes, Your Honor, I do.
And knowing all of that, do you want to continue with your plea?
Yes, Your Honor, I do.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
All right, and counsel, if you can please pardon your client.
Thank you. Ms. Stackpool, you've been placed on probation in this court, correct?
Yes, that's
And one of
correct.
those terms and conditions, we are not to use any non-prescription drugs. Would that be a fair statement?
Yes.
Particularly cocaine, marijuana, or any other prescribed drug, or any prescribed drugs that are not prescribed to you. Is that correct?
Yes, that's correct.
And you don't have a prescription for cocaine, do you? I'm not being facetious, I'm just asking that question.
No.
And did you test positive for cocaine on, February 24th? That's is good. The defense is satisfied now.
The court is also satisfied the plea is knowing, voluntary.
I'm sorry, I said 24th, I meant 25th.
No, 24 and 25.
Oh, 224, yeah.
25, yes. Yes. And so the court does find the plea is knowing, voluntary, and factually accurate. The court will indicate that technical violation number 1 will enter as a result of your plea. And as to the recommendation.
Your Honor, Ms. Stackpool, once she was released from jail, has undergone a lot of problems. She's lost her job. She's now working part-time with, I'm sorry, you indicated your part-time job?
Yes.
Yeah, where is that?
Oh, I am working for a sushi restaurant in Southgate, Michigan.
She had worked at the airport for 10 years, and under these circumstances, she lost her job. She's struggling. She's most concerned. She's been going to her testing. She's been successful there. She's Also testing twice a week at the guidance center. I'm sorry, twice a month, as well as prevention. She's presented documentation, which I believe she's already given to Natalie, is that correct?
Yes.
Including a letter from the guidance center. There's a copy, of course, which is good. You don't know if it's in the file.
I do not have that, so I'll have to look at that.
And this was. Great. And I don't know if you have the schedule here. She also has this, which she's given to Natalie. Yes, Natalie. Oh, I'm sorry. And I think, as part of her probation, Your Honor, the court, and I know, and I wasn't present at the original proceedings, but as part of her probation, it's my understanding that she's to have no contact with her son. And that was the terms and conditions. And I don't know why that was. I'm not suggesting that
Because he was the victim in the
he
domestic
was the
violence
victim.
matter. Yes.
I do understand you. And I guess that's really weighing hard on her. She accepts her responsibility, and that's one of the things that I assume, I don't know what he wants to have. I understand now he's 18, but that is one of the most, that I think is bothering her more than anything else, other than battling her demons. She's about to lose her house. And Your Honor, I believe that if we send her off to jail, pursuant to this, this jail at this point in time is not the answer, other than I told you not to do something and you did it. And I don't mean that in a facetious way, but she is attending these classes. She's taking care of her other problems. I know she owes money, et cetera, though she has been trying to pay that as well. My understanding is she just paid approximately $500. And so therefore, Your Honor, rather than implement the recommendation, I would ask the court not to do that, but to allow her for a jail review so she can see how things are working.
Well, I can't imagine that using cocaine is helping your situation, ma'am.
I agree, Your Honor. Yes, I messed up. I made a really bad decision that evening.
So what was going on that you decided you were going to use cocaine?
Just being lonely. I've never been away from my son this long. And just having to, since being sentenced to jail time, just my finances are just completely spiraling. And I'm really trying really hard to keep my head like above water and just to stay afloat. I have a much better support system in my life now than I did prior to my arrest. I've reunited with a lot of people in my family, which is helpful. I have a lot of people, I'm so sorry, that are also in recovery. So I have more people around me that understand what I'm going through. But I'm just really struggling with not being able to see my son. That's the truth.
And ma'am, I can understand that. But one of the conditions of the court, the reason one of the court entered one of those that condition was for the safety of your son. Because there were a lot of allegations or statements made, and perhaps you've had a substance use issue going on longer. And perhaps that's what was impacting your relationship with your son. I don't know. But I recall reading some of what his communications were, and they were disturbing.
Can I speak on that? Because that's not something, because I had a Zoom hearing because I had bronchitis for my sentencing. The statement that I feel that you're referring to was made by my ex-husband from my understanding and the information that Chris Shemke gave me, the attorney that I had at the time, Alexander, who was my son, the victim in question here, he actually really didn't have much to say as far as a victim impact statement. It was my ex-husband, Alexander's father, who had not been in Alexander's life for almost 5 years at that point. He was the one who made, I believe it was multiple pages long. I was able to read that statement. And there's nothing in those statements that are true. I mean, I wasn't in a position to be able to, prove that those things are not true. But I have never abused my child. I took a plea deal in this case. I mean, in the police report, it specifically states that I did not assault Alexander, that I never put hands on him. I believe that there was reference, I think I threw a Nintendo Switch in his area and it went over his shoulder. But as far as me actually assaulting my son, I've never assaulted my son, Your Honor. I've been a single mother to him, because as I stated previously, his father was not in his life. And the incident that we're speaking of that has led me to be here before you in this whole matter was involving an argument about his video game usage.
Okay, so ma'am, and I understand that, yes, there was a lot of statements that were made. There are also some, there appears to have been some other times that you've been,
and legal, yes, ma'am, and that was during my divorce from the man that I'm speaking of that made that statement in the statement that was sent. Yes,
so
ma'am, and I accept.
what I'm not going to do is I'm not going to go back and forth with what was put in the statement by your son's father and between you. Okay.
I understand.
So what I do know is that hopefully time will allow some sort of relationship with you and your son. However, the court had ordered you not to use any alcohol or drugs that were not prescribed. And you use cocaine. If you were to test right now, what is in your system?
Nothing, Your Honor. That is the one and only time that I've used since my arrest in October.
And who do you have here with you today?
My mom is here. My brother-in-law and my former stepdad. All three of those people behind me are very supportive and want nothing but what's best for me and my son both, which I haven't had that support in the past. I've really humbled myself and been very honest with myself finally, because nothing means more to me than reunification with my son. And I apologize to the court because I know that was the worst thing that I could have done that evening. I really am sorry, Your Honor. I'm so nobody's more disappointed in me than me. I have a great therapist. The group meetings that I'm attending are very good. They've been very helpful. I'm learning a lot. I have my psych evaluation to start my classes for domestic violence on the 25th. I've done everything else that I'm supposed to do. That was the one mistake I've made. And I'm so sorry.
All right, after hearing from counsel, hearing from Mr. Goldpaw, the court's going to order the following. The court's going to order you to continue and complete all terms of probation. You have a $50 probation violation fee that will be added to your balance. You're going to increase your testing. When was the last time you were tested?
That day, on the 24th, I also tested at the guidance center that day as well, because they are testing me every, bi-weekly. I will be testing with them also 2 times a month.
And obviously, Your Honor, she failed that test as well.
It was the same day.
The same day.
And I was honest with my therapist about it. I told her the truth.
All right, the court's going to order you to test today.
Okay.
The court's also going to order 10 days jail. I'm going to suspend that jail.
Oh, thank you.
Ma'am, let me be very, very, very clear. If there is one more violation, you will be serving that 10 days, plus the 10 days that are currently suspended from the bond violation, and if there's any other jail time that this court deems fit.
Okay, I understand, Your Honor. And thank you.
Do you need this paperwork back?
Please just provide records, please. Thank you so much. There was a copy that was sent to Ms. Shaw.
Let me copy of this, please.
And there was, I believe, the copy. Go ahead. No,
We're just making a copy.
yeah, no, I understand. I was saying, she did send a copy to Ms. Shaw.
My therapist directly did. Kathy Volke, I think is her last name.
Okay. All right, please have a seat over in probation and somebody will be with you shortly.
Thank you.
Thank you, Your Honor.
Good luck to you now.
Thank you.
If you guys will just have a seat actually and get a copy of your paperwork before we head that way.
Okay, thank you.
Next case on the docket.
In the matter of the state of Michigan versus John Christmas II, 25167. And for people, please.
Good afternoon, Your Honor. This is Governor Advocate for the People, P number 87297.
Thank you.
Good afternoon, Your Honor. John Goldberg, P30758, on behalf of Mr. Christmas.
All right, thank you, Mr.
Please put
Christmas.
your name on the record.
John L. Christmas II.
All right, thank you. And I apologize for you waiting. I know there's been
No
some back and
problem,
forth with that.
No
I
problem.
appreciate your patience today and addressing appropriately for court.
Appreciate it, Your Honor.
And today's the date scheduled for the adjourned pretrial. This had been adjourned from February 20th. And then at that time, I recall that there was a request by Mr. Christmas to return home to the apartment, and the court was not going to make a decision on that without hearing from your grandmother. And nobody could get a hold of your grandmother at that particular time, so we just set it over for today. And then,
That is correct, Your Honor.
surprisingly, your grandmother ended up showing up at the court later that day, right?
Yes, ma'am.
Okay, so, ma'am, can you please come forward?
Your Honor, they were also calling the wrong number as well. I got a call the other day.
Hi, and good morning, or good afternoon. I appreciate your patience in being here today, ma'am, and your name for the record, please.
Geraldine Christmas.
Okay, and so do you recall coming into the court on February 20th? It was sometime in the afternoon, I believe?
Yes.
Okay, so what prompted you to come into the court?
I had gotten a call from my granddaughter that for him to come home, they need to get verification from me. So
Okay,
I came down, but I don't know what ended up happening.
okay.
They said that he had to come get down there as quick as possible, and
Okay, and so this is the daughter, your granddaughter, that you watch her children?
that what?
You watch her kids, correct?
Yes,
Yes.
sometimes.
Sometimes, okay. And Mr. Christmas, this is the same sister of yours that you don't talk to very much, correct?
I said I don't talk to her often, yes, ma'am.
Right.
Because I just,
But yet
I
you happened to call her
just-
that day to tell her that you couldn't go home until your grandma came to talk to the prosecutor.
well, it's my sister, Your Honor. I speak to her every now and again. We just don't have a super, super close, like most people would assume it's close.
Okay,
I
but
just
I was
have
very
lots.
clear that you could not have contact with your grandmother even through a third party.
I did not tell her to contact me, ma'am. I just let her have information when she was asking me what's going on. If she contacts, that's I heard, but I was not, I heard your orders, man. Definitely heard your orders.
Ms. Christmas, it's my understanding that you don't want to proceed with this matter,
No, I
correct?
don't.
Do you feel threatened or harassed or
No,
coerced to
No,
not?
I do not. I do not.
Okay,
I really need him to help me out. It's a lot of things I really can't. I have AFib and I get short of breath very, very easily. And I can't like take the garbage out and mop the floors and stuff like that. But I do, I do enough.
okay. So let me just be
Didn't have to
clear,
do any.
let me just be clear with you, ma'am, right? I understand that you may need somebody to assist you with certain housekeeping services or housekeeping chores.
Yes.
Okay? But you also have the right and the need to be safe and free from any harm, threat of harm, or otherwise. I'm not suggesting that anything did happen or not. I'm just reiterating to you, ma'am, that even though you need some assistance at home, you also have the right to feel safe.
Right.
Okay? And I'm not making any judgment one way or the other as to what's going on, what's not going on, but you all are here, and so I'm just making sure that you're all aware that you have that right, even though you have the need for help.
I understand.
Okay, and so Mr. Matherly?
Yes, Your Honor, so we've heard from Ms. Christmas today, saying she doesn't want to proceed. And also, I've contacted the apartment complex where this incident took place because this is a malicious destruction of a building charge. So they are also the listed complainants in this case. I spoke to specifically, let me get the name, Kenora, who is the property manager at Residences on Penn, which is where this incident took place. And they informed me that they wish to not go forward with this as well, Your Honor. So people cannot move forward with this case, given that both of the complainants do not wish to prosecute.
Okay, Mr. Gopal?
Your Honor, we ask that the case be dismissed.
Okay, given that the complaining witness as well as the owner of the building do not wish to proceed, the court will dismiss this matter without prejudice. And there was a bond posted. Did you post that bond in your own name, sir?
Yes, ma'am.
Okay, so what I'll have you do is I'll have you go to the window and then just make sure they have all of your current information, and then it will get mailed back to you.
Yes, ma'am. Appreciate you. Thank you.
All right.
And Your Honor,
Thank
there's
you.
also my tender.
Then you'll report to probation after you stop at the window to make sure they have your current address. You'll report to probation. They will give you the information about having the tether removed.
Thank you.
Your Honor, may you, just for both parties here, can you explain what without prejudice means?
Yes.
Okay.
So just dismissal without
I didn't
prejudice.
hear what you said.
He asked for me to explain what dismissal without prejudice means.
Oh.
So dismissal without prejudice means that the people could refile the matter if either of the complaining witnesses chose to contact the prosecution to indicate that they would like to proceed forward.
Thank you, Your Honor.
Okay?
Thank you, Your Honor.
Okay.
All right. Good luck to you both.
Thanks for watching Verdict Watch. New court drama every day. Don't forget to subscribe and turn on the bell so you never miss a case. Leave a comment with your thoughts. We're watching too.